Welcome back, class. Today we're going into chapter 11, which has to do with the concept of consideration. Now, general perspectives. The purpose of consideration is to decide whether there's a valid contract once again. And in United States law, there always has to be consideration. Now, what is consideration? It's an objective evidence. It is objective evidence of a contract. And it's where A, the promisor receives some benefit for their promise, and the promisee gives up something in return. And that's what shows it's bargained for. It shows the intent. It's evidence of intent. And again, that has to be in all contracts in US contract law. And B, there's a legal detriment. That's one way to look at the concept, or a price. And that can be an act, a forbearance, or a promise of such for the promisee. So the contract can't just be consummated with a feeling of pride or warmth or amusement or friendship. So a promise to pay someone $1,000. It's not a valid contract without some consideration, or a promise to give someone your car. Without consideration, it's not a valid contract. Now, in 11.2, they discuss legal sufficiency. So for example, Phil offers George $500 not to smoke for a year. Is that contract enforceable? Phil can say that George already received the benefit of not smoking for a year because it's well-known health effects of not smoking. So he got the benefit of that. However, there is consideration in that case because George has the legal right to smoke tobacco, even though it's bad for him, and he's given up a detriment in that case. Now, adequacy. If courts will generally not inquire about adequacy. And when I was in law school, we were given the example of consideration being a simple peppercorn. So I'm holding a pepper shaker here, and we're talking about one peppercorn. Okay, so the example would be that, let's say, Grandpa Thomas will pay for your college education, your tuition, upon delivery of one peppercorn. One peppercorn on Labor Day every year. As long as you deliver to Grandpa one peppercorn, Grandpa will pay your tuition for that year. That is a valid contract, even though the peppercorn is worth very little. For me to buy the supply of peppercorns that go into the shaker is at most a couple of bucks at the grocery store. And that is a classic example of how the courts will not inquire into the adequacy of a contract. I'll go into another common one. Well, I may as well go into it now, but it's at the end of the chapter with cases. And that has to do with $1. $1 consideration is often the amount that's listed on a deed. I do a lot of real estate and real estate sales transfers. And a lot of times in the deed, it will say that the party of the first part gives to the second part, and there's a description of the property below that, in exchange for $1 and other valuable consideration. And the reason they do that is because, as I said, in the United States, every contract has to include consideration. And so in the deed that's filed with the county, there has to be in there that there was consideration. And real estate transfers are very complicated. They often involve a mortgage, there's a contract, and then there's a closing. And during that time between the signing of the contract and closing are a lot of contingencies. So financing, for example, someone has to get a mortgage. So it's not really clear what the cost of the contract being carried out is. Or between the contract and the closing will be some offsets. So maybe there's a inspection of the home and they discover that the furnace is broken or going to be broken soon, or the roof needs repair. So there's an offset. So rather than tinker with the deed and keep messing with it, lawyers will simply write $1 and other good consideration. And that's what you'll see in most deeds. And a court's not going to, generally not going to inquire in that. Now, we talked about an exception to that, and that had to do with, at the end of the last chapter, the defense of intoxication. So part of the factors that the court will consider in the defense of intoxication is the adequacy of the consideration. But generally, courts aren't going to look at that so it's not a fundamental factor. But consideration at all, or any consideration, is a fundamental factor in U.S. contract law. So you're always going to be looking for that, and that would be a defense. So think about it. Is there a quid pro quo? Is there a this for that? Was there an offer and acceptance? Well, there has to be evidence of it, and that's consideration. So I hope that clicks for you. If not, maybe when we get to the cases, it will. Let's go into some more concepts of consideration. We've got the threat of litigation. So we're talking about legal sufficiency doctrine applications, and one of those is the threat of litigation. So the covenant or the agreement not to sue somebody, that is going to be consideration. So in a case, Dideau v. Young, in 1965, a buyer is suing a broker and they missed some payments. They offered 5% commission in exchange not to sue. And that was considered consideration. That was ruled consideration in that case. We've also got a concept of an accord. An accord is generally a modification of a contract, okay? And we've got accord and satisfaction. And let's say Jan owes Andy $7,000 and she's supposed to pay by November 1st, okay? And let's see, she pays $3,500 and Andy agrees not to sue. Is that binding? That's the example in 11.2 that we're talking about. And Jan pays $3,500 by October 25th. That's the agreement, the modified agreement that they come up with. So in other words, Jan owes Andy $7,000, which is supposed to be paid by November 1st. And they make an accord to that agreement. They decide, well, Andy needs the money sooner. So Andy says, I'll tell you what, I'll reduce the amount that you have to pay me, but it's going to be by October 25th instead of November 1st. Now that accord, that modification of the agreement where Andy gets the money sooner is consideration. So that accord would be considered, or would be ruled adequate consideration. Let's see, settling unliquidated debt. So liquidation is when, a company or someone has lots of assets, a house, a boat, a building, things like that. And liquidating is essentially turning that into money. So sometimes someone will have an estate and they own lots of things, and in their will, they say it's going to be sold off or liquidated, and the proceeds will be distributed to their beneficiaries. That would be liquidation. And what we're talking about here is settling unliquidated debt. And we've got that as legal sufficiency or disputed debt. So for example, the example in the book is gallbladder surgery. It costs $8,000, but the doctor leaves a sponge in someone's body, for example. And in exchange for that, the cost of the surgery is reduced to $6,000. So that would be ruled as consideration. Another one is if someone writes a check and writes in full payment and it's less than what was in the invoice. And that depends. That depends on whether someone, the contract originally, or if someone writes on the memo of the check, what they put in there. So then another situation that we run into is unforeseen difficulty in carrying out a contract. So for example, Peter contracts with Jerry to build a house. And let's say the price is $100,000. And then when Jerry's building the house, he runs into quicksand. Well, guess what? It's kind of hard to build a foundation when you've run into a pit of quicksand. It reminds me of when I was young, when I was a kid, and early video games were coming out, and quicksand was a very common hazard that you run into when you're playing these early video games. Or in cartoons when I was younger, quicksand was very common. I haven't run into quicksand in my adult life, but when I've taught this class and I brought up quicksand, there's a number of people who have dealt with it when they're doing excavating in property, on dealing with construction and things. So it's a fairly common thing. And the example in the book is Peter contracts with Jerry to build a house, runs into quicksand. Jerry adds $10,000 to finish on time. And that would, the question is there consideration there? And it's arguable, it depends on the facts of the case, but it could certainly be considered, or could be ruled as consideration in a case like that. Let's see, we've got the concept of a pre-existing duty. So let's say the example in the book is Grandpa promises his 16-year-old grandson, David, $50 not to smoke. So we're revisiting the idea of consideration when it has to do with the legal ability to purchase tobacco. But in this case, David's only 16. So David has a pre-existing duty not to smoke because David's underage. Now, that's the example in the book, but I had a student bring up the fact that it's not illegal to actually smoke cigarettes when you're under 18, to smoke tobacco, but it is, you just can't purchase tobacco. So, if David's caught with cigarettes and he has a source for tobacco, he's legally allowed to smoke. So it's just an interesting detail that it seems like the book doesn't contemplate. But that's why consideration is fascinating, because it's always arguable. Was there consideration in the case? Something as small as a peppercorn can be considered, or can be ruled consideration. All right, there's the idea of a illusory promise. An illusory promise, the example in the book is Lydia offers to pay Juliet $10 to cut her lawn. Juliet counteroffers to cut it if she feels like it. That's not enforceable because there's not any consideration there. Exclusive dealing agreements. So we're talking about franchises here. We're talking about, let's say you want to set up a McDonald's, and rather than start from scratch and start your own restaurant, you get a franchise agreement with McDonald's. What's the consideration there? Now, an obligation to use reasonable efforts to promote and sell the product or services is itself consideration. The other one brought up in the book is output contracts and needs contracts. And we've got the reasonable person standard. We talked about the case last time having to do with the eel skins and the whip company. And in that case, if you look at it, there is consideration there, because we've got, as a reasonable person, you would think that if you delivered the eels on a consistent basis, the eel skins, and they were paying you for it, then there was consideration on both ends. You're getting the benefit of the skins to create the whips, and it's a mutual contract. And those types of contracts are ruled to have consideration in place. All right, now we're going to talk about in 11.3 promises enforceable without a contract. And in the common law, past consideration is generally not enforceable. So, for example, if a person who, the example in the book is if someone who lost a pet promised $50 and offered $20 when he goes to collect, it's generally not enforceable. So we've got exceptions to that, and promises revived after a statute of limitations. So for example, you've got, let's say, a credit card, and a credit card is going to be considered a contract case, and the statute of limitations is 6 years. But if someone renews that contract by continuing to use the credit card, then that moves the statute of limitations starting point each time the person uses the credit card and activates the contract. Let's see, we've got also voidable duties. So if a minor makes, we discussed this when it had to do with real assent in the last chapter. Voidable duties, for example, if a minor makes payments, let's say a minor takes out a credit card and then they make payments after they're 18. Well, that's going to create a binding duty where it was voidable before that. There's the example of promissory estoppel, and I think that is a bit complicated for Business Law 1, but let's see if I can explain that. Basically, you can't have things both ways. You can't say that, I talked about the Reader's Digest case where, someone was selling their home and they didn't disclose that there were, at least people believe there to be ghosts in the home. And, you can't publish in Reader's Digest that there's ghosts in the home and make money off that, and then fail to disclose it to buyers later on. That was the ruling in the court in that case. So we've got that exception here. All right. Promises that are enforceable without consideration by a statute. So the UCC allows a claim or right of discharge without consideration or breach. That's one example. That's one instance. Another instance is bankruptcy. And I've talked about bankruptcy a little bit. We don't cover it as a chapter here, but I think you'll learn about it if you go on to take Business Law 2. And bankruptcy, the idea there is we want to encourage entrepreneurship, and we don't have debtor's prison in the United States. So we want to encourage people to take risks. And if a business doesn't work out, they can declare bankruptcy. There's different types of bankruptcy. Some of them involve the court appointing an administrator over a business to see if maybe someone doing it without a conflict of interest changes how the business runs, or they can simply liquidate. I talked about liquidation earlier. Liquidate all the assets and distribute it among the creditors. And those are sort of the extreme examples of bankruptcy and what's available. And let's see, we've got international contracts, and I told you that no consideration is required with international contracts unless the country that's a party has the same fundamental consideration rule that we're talking about in this chapter. All right, so just to review before we go on to the cases, consideration is sort of the evidence that a person is giving up something, some detriment, they're paying a price. When you go through a drive-through, for example, just think about, I don't know, I like more and more the idea of a drive-through because we don't have the same dining experience during COVID that we've had recently, that we had before then. So a drive-through is a more common thing, I think. And it's pretty simple to compare the execution of a contract to that. And you order your food, so you're expecting something. And then you go up to the window and you pay. That's the consideration. you're expecting what you asked for, what you bargained for at the time you ordered your food. And if there was consideration, there's a contract. So in a simple way to put it, I think you can understand it from that way. All right, talking about some cases, we've got the Board of Control of Eastern Michigan University versus Burgess. And in that case, at the trial level, well, just so Burgess, there was this agreement between Eastern Michigan University that they could purchase this property. And of course, there was that agreement that I talked about earlier, where it was $1 and other consideration. And it involved an option to buy it after a certain amount of time. And the board control of Eastern Michigan University decided to exercise that buying option. And Ms. Burgess, who owned the property, said, no, the property is not that cheap. And in fact, I didn't receive $1 or any other good consideration. And the court reversed that case and remanded it, finding that there weren't facts on the record. Okay, so this is the appellate court now deciding on law and just looking at the record. So they're not considering the credibility of witnesses, but they decided that in this case, no one was claiming that Burgess received even $1, let alone the other good consideration that's stated in the contract. So they said that merely the statement that was submitted as evidence of a contract was, created a rebuttable presumption. In other words, the court still had to look into the facts and see, was there any consideration at all? And there was nothing. And I told you earlier, even a peppercorn will be considered, or will be ruled consideration. Even $1 would be considered, or would be ruled consideration. And in this case, they said that they remanded it back and wanted to see if there was any consideration in this case. So I don't know what the ultimate outcome of the case was. I imagine they created some kind of settlement or didn't pursue it, but that's the appellate ruling of that court. All right, the next case is Denny versus Reppert. And in that case, we've got a bank robbery, okay? So in this municipality, there's a $1,500 reward for anyone who helps to solve a bank robbery. And there was a bank robbery, and there's basically three plaintiffs in this case, three groups of people who believe they're entitled to the reward. You've got the employees of the bank. And while that's certainly a traumatic experience, that they went through, they were robbed, and someone was threatening them. There was the police that helped solve the robbery, so they ended up apprehending the suspects and charging them with robbery. There was another person who's sort of in between. The person was present at the bank at the time. They were a police officer, but they were at the bank outside of their jurisdiction, and they were off duty. So you've got three different parties: the employees, you've got the local police, and then you've got someone who decided to help out, who's a police officer and could assist the police, could assist the bank tellers. And they all worked together to describe the suspects, to give the local police the leads that they needed to solve the crime, and the crime was ultimately solved. And so where does the award go? Well, the court determined in Denny versus Reppert that the employees had a pre-existing obligation to help with solving the bank robbery. So, it's not a normal part of your job as a bank teller. You don't get robbed every day. But the court found that that could be something that's part of your employment to, help find the robbers. Then the local police, obviously, they have a pre-existing obligation to protect the community from crimes like robbery. So they had a pre-existing obligation as well. Now, the outside deputy, that person They didn't have that pre-existing obligation. While they're a police officer, what they do on their own time is up to them. You're not always obligated to help solve crimes when you're off duty. Plus, they were in another jurisdiction. So in Denny versus Ruppert, it was pretty easy for the court to distinguish between who was giving consideration and who had a pre-existing obligation. All right, last case is Gross versus DL Specialties International. And that involved a contract that went through certain accords, modifications, because Gross had an employment contract with profit sharing incentives that survived the sale of the dairy company. So there was an accord, like I talked about earlier. And in that case, basically you had the dairy contracting with the plaintiff, with Gross, and they came up with a formula for milk that people with lactose intolerance are able to drink and not have a reaction to. And in that case, the dairy sold to subsequent owners, and the subsequent owners changed the contract with Gross, and Gross didn't get any benefit for those changes. And the court ruled that those were invalid because there was no consideration received by the new owners. Gross didn't have any detriment. Gross wasn't given even $1, nothing, no consideration. So that is invalid. Contracts are invalid without consideration. That's the basic lesson. That's it for today. And I look forward to the rest of contracts. And I hope you do too.